you, I'm gonna move quickly. We're gonna run this like a German railroad. We're gonna head out of the station right now at full speed. And I know you may have questions. I've put my email on the cover of the slides, so I'm easy to find. There it is, Wayne@ksa.org, and feel free to follow up with any question after the fact. And you can even call me. I didn't put my phone number on there, but it's readily available. But I'll be glad to give it to you at the end. Uh, and I just tried to pick some, since our time is limited. I know y'all got lots of other things to do. I just tried to pick the low hanging fruit to talk about today. And Keith, if you'll go to that next slide, you'll see what that low hanging fruit is. These are things that, as a principal, you'll, I suspect, run into one or more of these in some form or fashion, although some of them don't affect you in a direct way. Confirmation of the Commissioner of Education. I'm going to talk about that in a larger sense, like Commissioner Kinney talked about. Things are changing as we speak. That's one of them, along with some other things. I'm going to try to refrain from political statements and editorials, but many of these issues, including the first one we're going to talk about, are very controversial and delicate social issues, and there are a lot of different opinions, and so I'm going to try to just give you the dragnet version, just the facts, and I may throw in an opinion here and there, but it will be, I hope, because it's relevant. So let's move on right into that next slide. I don't know how many of you, I talk to districts on a regular basis, principals and schools, about addressing the needs of transgender students in their school. And we have that, it's a lengthy conversation. And the reason for that is very simple. There is no law of the land in the United States on that issue. I'm going to go into some background on the next slide, but on this slide, I just want to focus on this case. We don't have a U.S. Supreme Court decision on this case. We don't have a binding Sixth Circuit Court of Appeals decision. We lie in the Sixth Circuit. Kentucky does in its jurisdiction, Kentucky, Tennessee, Michigan, Ohio, and there's no real binding case from that court that would guide us. We have some law in Kentucky now as a result of the 2023 General Assembly that does provide some directive in some issue, but not in the entire issue. The entirety of the issue is what is the status of transgender students under particularly Title IX. This case, this Adams versus School Board St. Johns County, a Florida case, is an 11th Circuit case. It's not binding in Kentucky, but it is something we can look to for guidance. One of the things we do as attorneys, if we don't have direct authority in our jurisdiction, we look around the country and see what's happening in other places. And so that's why I've included this case. Plus, the reason I included is the potential it could be decided by the U.S. Supreme Court. I've just looked at every source I can find, and I don't see this case being petitioned to the Supreme Court for a decision. So I don't know if it's just over with at this level, or if there's still something working at the lower courts and it'll come back. Cases sometimes tend to yo-yo in the federal court system. They'll come up, they'll go back down, they'll come back up. We've had a number of cases have that happen. So I just want to share it because it's the latest decision, and it has to do with, as you might expect, and you can see the red language there is quotes from the judicial opinion, from the court's opinion, but it's about a transgender student and bathroom usage, something we run into pretty regularly. And in this case, in the 11th Circuit, the full court, this is all the judges of the 11th Circuit, not just one panel of judges, of 3 judges, but all of them, 15 of them, I think, deciding that the district's policy, which said students must use bathroom facilities based on their biological sex at birth, the court upheld that policy. Now, other courts around the country have overturned similar policies. This is why, as an attorney and certainly as school leaders, we would like to see the U.S. Supreme Court make a binding decision here, but we don't have one, so we're kind of left to our own devices on this. But in this particular case, the court made note of the fact that under the Title IX claim, that Title IX actually specifically allows for gender segregated bathrooms, and so the court said there's no federal right at stake there. And then the equal protection would be a more shall we say, abstract claim, but the court disposed of that by saying that, look, the policy furthers a legitimate governmental objective of protecting privacy. They went to that argument of the privacy of other students. So again, you see a kind of a mix of issues here, and we see this in all these cases. Now, I would tell you that regardless of your views of how schools should accommodate transgender students, you can find a case or a law around the country, more than one in most situations, that reflect your particular a particular individual view you or I might have, but that doesn't help us in deciding the legal issue as a binding precedent that we, as the folks who give advice to educators, can rely upon. Go to the next slide, Keith, and you'll see exactly what I'm talking about there. I think this says more than 20 states. It's probably closer to 30 states have either current litigation or legislative action that directly addresses transgender students in K-12 schools. As you know, we have it in Kentucky. I'm going to get to that in just a minute. But and that legislation, those board policies, those federal and state court cases, they're of every persuasion, every stripe. So if you're looking for something that supports your point of view, trust me, if you do a scan, an environmental scan of these cases and statutes and policies, you're going to find something that is reflective of my personal opinion or your personal opinion. But again, that doesn't help us as a binding legal precedent. And you just see the divergence that we see in these cases. The state of Connecticut was sued by parents and athletes, high school athletes, for allowing students to compete based on gender identity, compete in athletics. West Virginia was sued for not permitting students to participate based on gender identity. So again, polar opposite lawsuits based on opposite policies. Maryland was sued, the state of Maryland was sued for refusing to inform parents of transgender status regarding their child. However, the New Jersey Department of Education sued local districts for notifying parents of this same thing. So again, how do you answer that as a school leader or as a lawyer when you see this and there's no binding law? And there may be, in some jurisdictions because states have acted on this, but for a long time in Kentucky there wasn't. We do have a law in Kentucky now. It's generated its own controversy, as you probably know. And that is Senate Bill 150 from the last legislative session, 2023. And what we've done in Kentucky by legislative directive is requiring parental notification when a student announces that to a school employee, teacher, assistant principal, I would argue even a guidance counselor who have some privilege under law. I don't think it's an absolute privilege, but when a student says, I believe I'm transgender or I'm identifying as transgender, and please don't tell my parents, Kentucky law now says you can't honor that you're required to do so, and that failure to do so places you at risk as a school district employee and certified educator. Same thing with restroom usage. We have by state law said bathrooms are based on biological sex at birth. And also local districts cannot have policies requiring non-conforming pronouns. That's what we've addressed in legislation in Kentucky. Now, you can agree or disagree with any or all of that, but the point is that's what Kentucky law says. So again, without some federal with Supreme Court guidance, you're left in the lurch, because the other thing we know is that the U.S. Department of Education Office of Civil Rights has said they're going to enforce against complaints of validated complaints of discrimination based on transgender status. So in some cases, you could be following Kentucky law and yet get an OCR complaint saying that you're violating that student's federal rights. So it's really put Kentucky educators in a bind, and certainly other states are experiencing the same thing. That, do you comply with state law at the risk of getting some kind of federal intervention, or do you defy state law at the risk of your own professional licensure? It's just really an untenable position for educators to be in, and we need to fix it. But the other thing you'll notice is the Senate Bill 150 doesn't cover everything. Understand it says prohibits policies requiring non-conforming pronouns. That's board policies. I'm certainly aware of schools and individual teachers and districts where there's a different practice. It doesn't prohibit certain practices. If you want to honor that, it simply says the board can't have a policy that makes a requirement in regards to that. So we could spend a lot more time on that. I have a whole list of cases we could go through showing different outcomes, but our time won't permit that. So Keith, let's move to the next slide. And we're getting into free speech now with students, and then I will get into employees, and particularly free speech. There's a lot to free speech, as most of you know. You've had a school law class. You know about the Tinker case with the black armbands and the Vietnam War, and what that said about substantial disruption of the educational process. Everybody knows about that, but we've kind of gone to a different phase of that based on the proliferation of social media, and most free speech cases now are social media driven, with students, sometimes with employees, but often with students. And we just had a case a couple of years ago called the Mahanoy case, one of my favorite Supreme Court cases about education, because it involved a young lady, teenager, sitting in the place called the Cocoa Hut in Pennsylvania. I'm going to visit there one day, see where First Amendment law really is made. She was in the Cocoa Hut on a Saturday afternoon, sending vulgar emails out to all of her friends about cheerleading and softball and school, and the school suspended her for that, and that ended up in the U.S. Supreme Court. Won't go back and talk about that case a lot. It's a couple of years ago, but you can find that case very easily and read it. It's a lot of fun. But that case spawns other cases, and so I'm more interested in kind of what I call the first generation responses, and it had to do with what is the school's authority to discipline students for off-campus behavior, particularly as it relates to social media. As you know, many kids go home on a weekend, 2 o'clock in the morning, they're going to send some ugly email out about some other student or the principal or the teachers. And what can you do about that, if anything? And this is kind of the first generation case after the Mahanoy decision, which said that schools have to they really said schools should be careful in restricting or intervening or punishing student behavior, student speech off campus and away from school. But they didn't say you can't do it at all. Well, certainly you can. And that's what this case is about. These students were expelled because they prepared and disseminated off campus, off school time, off school computers, but they made a social media post that was racially discriminatory. It was ugly. It said really horrible things about fellow students, and the court, the school district expelled them, and the Ninth Circuit, after going through the judicial process, the Ninth Circuit upheld the school's right to expel those students. And the court based that on this notion when it says there has to be a sufficient nexus, a connection to the school in order for the school to be able to regulate it. The court said, this is bullying, it's harassment, and it would create liability on the school district if they failed to act and something occurred, some kind of harm occurred to these students who were the object of this offensive and really hostile social media posting. So it's always going to be a fact-driven inquiry, but I share that case simply to reaffirm you can act regarding student behavior, and it doesn't have to be social media, but it most likely is in our day and time. But make sure you handle that thoughtfully. The court said be careful don't try to go too far, but by the same token, you certainly can intervene if it is of such a nature that it requires your intervention, if it's bullying or harassment. So that's an interesting case. Again, not in Kentucky. That's a Ninth Circuit case. That's out on the west coast of U.S., but still good guidance for us as we try to gauge how far should we go in trying to regulate student speech off campus, particularly if it's social media based and aimed at some context at school, other students, or a school-based kind of environment. So what about employees? What about their free speech? The Tinker case said students have free speech, but it also said employees have free speech. It wasn't about employees. There are other cases about employees, and we can spend a lot of time on those. But this is the latest one, and I kind of got a charge out of this one, especially in our current political atmosphere. It's kind of fun because I can just see the intentional antagonism going on between this teacher and his principal. This is another Ninth Circuit case. This is from the West Coast. California, in particular, is ripe for these kinds of issues, but this one is fun to read because you can just see the interpersonal dynamics kind of under the surface. This teacher wore a MAGA hat to a school PD event. It's a 2-day event, and he wore the clearly political message that is sent from the hat that says "Make America Great Again." Everybody understands what that means, and fine, everybody can have their own political views about anything. His principal said, if you wear it tomorrow, you're going to have a problem. So, of course, you know what happened. He wore it the next day. Now, let me point out here, if you want to have rules about what people can wear to PD events, you can certainly have those rules. Those rules have to be reasonable. They have to be fairly applied. So you can say nobody can wear a hat to a PD event. Okay, that'd be perfectly fine. You just can't say nobody can wear a hat that says this or says that. You have, if you're going to restrict hats, you just say no. This is a baseball cap, okay? And my question is, why are you wearing a baseball cap to a professional? The word professional is in the title, okay? Why are you wearing one? But anyway, I digress. He got this. He wore it the next day, and of course, he got suspended or something. I forget exactly what the discipline was imposed on him, but the court said, you know what? You were being selective. First of all, the principal had allowed other political expression at the event. It's pretty clear in this case when you read the facts that it had nothing to do with the fact that the principal was upset about wearing a hat. She was upset about wearing that particular hat. And again, I don't care what your political persuasion is. The principal clearly expressed personal animosity toward the teacher. But that can't guide your actions on employee speech just because you don't like it, just because you disagree with it, just because you find it insulting, whatever it might be. Employees, when we're regulating speech, whether it's students or employees, one of the things we cannot do is regulate what's called viewpoint. We cannot engage in viewpoint discrimination. If we allow, let's talk about students. If we allow the student Young Republican Club to meet, we have to allow the Young Democrat Club to meet, and we even have to allow the Bernie Sanders for President student club to meet. You can't pick and choose. You've got to say, if a non-curricular student group wants to meet, we allow them to meet regardless of their point of view on political or social issues, unless they're engaging in threatening or illegal behavior, clearly vulgar, those kind of things. Those restrictions are perfectly fine. But just to say, we're not going to let you send your message because I don't like it. That's unconstitutional. So same thing with employees. We can restrict public employees' speech when they're doing their job. We can restrict that, and as long as those restrictions are reasonable, again, meet some other criteria. But we can't just say, well, I'm going to let this person make a political statement, but I'm not going to let you make a political statement because I disagree with your political statement. Those things don't fly, and that's what we see in this case. So again, this employees' social media, even away from work. We could spend a lot of time talking about that, but you can intervene. I talk to principals and superintendents all the time and HR folks about intervening when an employee has done something on his or her social media that interferes with the mission of the school district. And again, that's something if you took my school law class, we'd spend a number of hours on that, but we won't today. So that's commercial for the next place I teach school law, where I'm at my 4th university now. So once they get tired of me, I guess I'll go to my 5th one, Keith. I don't know. Let's move on to the next slide. And I want to talk about parental rights. And the reason is this is reemerging nationally as an issue. It's coming to prominence in terms of who's in charge of what happens to kids at school. For a long time, we've struck a balance there between parents and educators. We have this theory, or it's not a theory, it's a legal principle that is called in loco parentis. And what that means is in the place of a parent. And as a legal matter, we have always said when kids are at school, teachers and administrators stand in the place of a parent in terms of regulating the behavior of that student. You can act toward that student as a parent would in terms of supervision. But again, that's always a kind of a balance. Unfortunately, the term in loco parentis more and more each day is starting to mean crazy parents, rather than in the place of a parent. And I say that as a parent, but what we're seeing as legal issues is that the pendulum is kind of swinging back to the preeminence of parents in making decisions about their students. And you see that again in red. That's from Senate Bill 150. And that's a pretty mild statement. I don't know that any of us would disagree with that. School districts and district personnel shall respect the right of parents to make decisions regarding the upbringing and control of students. That's a hard statement to disagree with. But where we're seeing that manifest itself, not just in Kentucky, but nationally, is that parents are wanting to have veto power in large measure over some of the things that happen at school. And we're not just talking about counseling or mental health or psychological assessments, but we're talking about you can't make my child read that book. You can't, and that's gone on for a long time on a small scale, but it's becoming a much larger scale now, or I'm not going to let my child take that curriculum. We had a bill that didn't pass that had some far stronger wording in it about parental rights. And we've got probably more than one that have already been introduced in this session of our General Assembly that propose some really expansive language about parents coming to school and saying, I'm not going to let my child be a part of that. I don't know where that goes in terms of disruption of curriculum and a number of things, but I just put a couple of examples on there about how this manifests itself. In Nevada, parents actually sued the school district because they claimed the homework assignments were, in their words, obscene and violent. So they're asserting themselves in court. Unfortunately, many of these things could be resolved if reasonable people sat down across the table from each other and had a good faith conversation, but unfortunately not everyone's willing to do that. So these parents sued, and I looked that case up and I don't even remember what the obscene and violent homework assignment was, but again, that was their description. In Georgia, you see parents who filed a lawsuit and won for being the local school board shut them down when they were reading book passages at the board meeting. And understand they were reading book passages from books that kids in the school were reading, books out of the school library. And so they sued the district and prevailed on that. So we see that issue. This in Virginia about 2 years ago, this was a huge issue in the gubernatorial election. And so I expect it will continue to grow nationwide and in our state as we try to strike this practical and legal balance between what's the role of parents and educators in what goes on at school. What are those respective roles and how do they interact? The next slide, Keith. is about charter schools and dress codes. And they're going, why is that? Dress codes are perfectly legal. You can have about any kind of dress code you want. So that's really not much of a legal issue. But the more interesting part of this is kind of down. You have to get into the weeds a little bit in this case. Now in Kentucky, we just had our charter school law declared unconstitutional by a circuit court. So that's still subject to appeal. And we don't know how the outcome of that is. But right now, there will be no charter schools in Kentucky for the foreseeable future. So this is not necessarily, this may still be an abstraction to us, but here's what I wanted to point out as to where this goes. This is in North Carolina, and the charter school in North Carolina imposed a dress code for no skirts only for female students, and the parents of the female students who wanted them to wear shorts or pants or whatever filed suit and said that this was a violation of Title IX. And the charter school said, you know what, we're not bound by Title IX. Well, I don't want to get too picky, but the North Carolina charter school is exactly like the Kentucky charter school law in that it says that charter schools are public schools. They are public schools. So public schools certainly are bound by Title IX. So that legal argument is just false on its face. But I think my point in even sharing this is I think this is where charter school arguments go. Is charter schools are created as quote unquote public schools, and then when they're run by private organizations in many cases, and they just say we can do our own thing and you can't do anything about us. You're not the boss of me. That's the charter school argument, and it is here. And the Supreme Court didn't hear the case, but the Fourth Circuit allowed the claim of violation of Title IX to continue, and I think they should have, because I don't necessarily, you can agree or disagrray with the dress code, but whether it's a Title IX issue is certainly true because it's a public school. But my point is, charter schools sometimes don't want to. They want to be public schools because they get the state funding, and then they don't want to be public schools to play by the rules that you play by. So that's just that internal dichotomy that exists in the charter school area. All right, next slide is about expulsion, and this is just an FYI. You may know this already, but in 2023, you may have changed your student discipline codes because of this, but the General Assembly of Kentucky expanded the basis of expulsion and suspension for Kentucky students in response to teachers saying in large numbers that the biggest issue for them was not salary, but instead was being able to manage discipline of students and not getting support from parents and sometimes administrators in their claim. So the General Assembly responded with this piece of legislation, which significantly expands the authority of local school boards to expel students and then deal with their placement after expulsion. They can be placed in virtual placement or any number of things. And it also created a new kind of what I call a 3 strikes and you're out approach to disruptive students, students that are disruptive in the classroom. If that happens on 3 occasions, and it doesn't mean they have to have done anything, caused harm, assaulted, threatened. It's just disrupting the teaching and learning. If that happens 3 times, those students are subject to suspension or expulsion. So it's kind of a 3 strikes, you're out, and that has to be implemented, of course, at your level, at the individual school level. So you and your teachers probably need to be on the same page in regards to implementation of that process. And I see my time is quickly slipping away, but you can look up House Bill 538 and see what's in there. I'm going to skip the next slide, Keith, which is the confirmation of the commissioner, because that's sort of not that big a deal for us. But I'm going to go back to book banning, excuse me, which may include book burning. I don't know. But this is also starting to bubble up all around the country. I mentioned the Georgia lawsuit about the parents who won the court case against the school district. We see this coming in all kinds of different forms. I've actually had a call from a Kentucky school district within the last 2 weeks about this, and that is we passed a law about materials that are harmful to students, and parents can challenge that. Well, that's happened in Kentucky, and it typically comes in the form of parents pulling out library books and bringing them to the board and saying, why are you letting kids read this? That's typically how this manifests itself, but it's happened in a lot of different ways, and I just give you 3 or 4 examples there. Librarian received death threats over opposition to book banning. Student filed a lawsuit saying you can't ban books from the library. Florida, this one was interesting. A publishing company sued the district for banning some of its books. The publishing company says we have some right to have these books in the library. I don't know how far that's going to go. I'm not sure that one works. But in Georgia, that's perhaps the most far-reaching incident. The Office of Civil Rights is investigating whether it's a Title IX violation to ban only certain books that is discriminatory in nature. Example I would use, this isn't what they did, but what if a district said, we're going to ban all the books by Jewish authors or about Jewish characters? That's hot in the news right now with Israel and Hamas and Palestine. So what if a board said, we're just going to do that? Is that a violation of federal law? I'm not sure we know the answer to that. We could have strong opinions one way or the other, but that's what's going on in the Georgia case. So just look for that to kind of come your way in the near future. And very quickly, I got about a minute left. I'm gonna share, just leave us on a light note with a smile of hope. The case of the year, the next slide, and this is what you signed on for when you became a principal right here. This is a parent who's suing a school district. She's got 2 boys in an elementary school. She's suing the district because they won't let her volunteer. And the reason they won't let her Snooks, her name is Victoria Snooks Treese. The reason they won't let Snooks volunteer is because she has material posted on the OnlyFans adult-oriented website. I have no familiarity with that website, but as an attorney, my due diligence, I had to look and see. No, I didn't actually. That's a joke, but it's an adult-oriented website. Okay, you do the math. You know what that is. But the funny part of the case, they said, since you've got these videos out there online, which people, by the way, pay a fee to view, as you might expect, we're not going to let you volunteer here. So she sued the school district. And in her lawsuit, she says that her videos were circulated to staff and employees who were not in need of the information. And I chuckle because I'm absolutely 100% sure that claim is true. Okay, I'll just tell you that right now. And I don't know anything about this case, but I'm 100% certain that happened. But the better quote is from the plaintiff, Snooks Treese, who said, "I'm doing my job in private." Now, I would submit that based on that statement, she either doesn't understand the internet or doesn't understand her job, because she is certainly not doing her job in private. It's very public for anybody who's got enough money. I did get a picture of her lawyers, and that's the next slide. You hear about a lawyer in Kentucky for the people. This law firm is apparently for the dumb people. And you may know those 3 guys, but it's been fun being with you. Sorry, we're out of time. Like I said, you got my email, wayne@ksa.org. I'm happy to give my cell phone, 859-361-0887. Feel free to call me during reasonable human waking hours. And Keith's right. I answer most of the time. Sometimes I don't answer, but I always call you back if I don't. But 859-361-0887. Y'all have a great rest of this very cold day.
Wayne, thank you so much. We really appreciate your time and your expertise that you've shared with us today. Very much appreciated, my friend. And I hope you have a great trip out there to Aruba that you're going to.
Yeah, don't I wish. Y'all take care.
Thanks, Wayne. All right, guys, this is the last time we'll all be together as a group. So let me just go ahead and say, I hope you have a great afternoon. These breakout sessions this afternoon are wonderful. You're going to have a great time, but we won't meet back together at the end. Your last thing that you'll do is meet with your co-ops in that last section of the day. And so I'm going to open the breakout rooms back up, and our next breakout room session will start at 12:40. Get those rooms and pop them open. You'll join the very same way that you did in the beginning of the day. So those rooms are now open. You can join them, whichever one you want to go and see. That breakout room session should be available to you. And breakout room hosts, if you'll head to those rooms now.